Acting. Quite a character.
Good to be back home.
Welcome back. Welcome back.
You are still there and here.
This is where I belong.
Great.
Honorable Justice Nariman, President Sir, respected seniors, dear colleagues, the House is full, as is obvious, and it shows the exuberance and the excitement that the bar has to hear the lecture. And Justice Nariman did say that he had a very exhausting day in the court, and till he gets his coffee, I'll request President Sir to please welcome Honorable Justice Nariman and say a few things.
First, you must. May I request Aishwarya ji to welcome Justice Nariman with a bouquet of flowers, please. And I want a ovation for Justice Nariman. Justice Nariman, good evening. I don't think these people who have come have bargained for that, so I won't take the risk. Good evening, Justice Nariman. Welcome. Good evening, everybody. It's really a great moment for us to have with us Justice Nariman today, who till the other day belonged to us. And I have no doubt in his heart he still lives here in this library, in these corridors, and on this side of the bar. It's very interesting how this lecture came about, and I must reveal a little secret with all of you friends. If you want any relief from Justice Nariman, which he can never deny, you should find him when he is walking outside the court. He was walking in the Lodi garden and I accosted him. I told him that we have been wanting to invite him for a lecture series, and he readily agreed. We discussed few of the subjects and he suggested a subject which is truly outstanding and extremely, the subject itself is path-breaking. Now in Justice Nariman, we have somebody who really can wear too many hats. He not only was an outstanding lawyer, and I have no doubt that in this short span, he has convinced all of us that he is going to be one of the most outstanding judges on our bench. But there are many other qualities that he has, and many of you may be aware about them. If he was not such a great lawyer, a great judge, he would have been perhaps a great musician. He would have been perhaps a equally great religious leader and a preacher. He would have perhaps been a great historian. All these things Justice Nariman combines in himself, and that's something which really makes him a very special judge. On legal history, I can definitely vouch, having shared, I think, thousands of coffee cups over our canteen tables, that the legal history that he knows about, not only for India, but in the United States as well as United Kingdom, is absolutely unbelievable. And with his elephantine memory, he just doesn't miss anything, including which judge had what kind of a character, what kind of a life, perhaps what drink he had and what girlfriend he had. So, so Justice Nariman truly is a legal historian in that sense. Today's subjects, friends, is one of those subjects which he can only, and he perhaps is the only authority who can enlighten us on this extremely interesting subject. We all, deal with laws all the time. We all deal with judgments and journals and all that. But we really don't know what goes behind this, in the corridors of the judges' chambers. And this is very important, how law is molded, how over centuries or last at least 200 years, how judicial system has functioned in countries like England and United States, as also in India. And that's something which we really all must know. I mean, young and old, all of us must really be aware about that. So today's evening promises to be a very, I would say, very enlightened evening. And I'm sure each one of you are looking forward to hearing Justice Nariman on this very beautiful subject. I thank him from the bottom of my heart on behalf of all my colleagues here in the bar and myself that you have agreed to be here and talk to us. But I can only promise you one thing, Justice Nariman, that this is not the first and the last time that you will be invited here. We are going to bank on you, unless you stop walking in the Lodi garden, of course. We are going to be banking on you to come and talk to us from time to time. And as I have said on more than one occasion in last few months, that this kind of a camaraderie between the bar and the bench is absolutely necessary. Unless bar and bench have a very personalized relationship outside the court, outside the justice delivery system, outside decision-making process, the institution can never grow. And I think for institutions to grow, it is very important that we have a better relationship between us. So having said that, I welcome you and I request you to address us this evening. Thank you very much.
Mr. Dave, my beloved father, and all of you, my beloved friends. This year happens to be the 800th centennial year of Magna Carta. Now, all of you have heard of Magna Carta. There are one or two little known facts about Magna Carta which I'll put before you. One is that the document is in Latin. What was the spoken language of the day in King John's time in 1215 AD was French. So it was not really something which was supposed to be understood and which was supposed to percolate downwards. First. Second, Magna Carta was annulled by Pope Innocent III almost immediately. 15 June 1215 was when King John was forced to sign it by the barons. And by August of the same year, Pope Innocent III, who was a very strong and great pope, actually annulled the document. So what Magna Carta really is known for is more the things done in its name than what was actually done under it. Very little was actually done under it. What is oft quoted is the 39th and the 40th articles of Magna Carta. The 39th article is something like our Article 21. It doesn't speak of life, but it certainly speaks of liberty first. And it also speaks of property, possessions. So for the first time it was laid down that the king, in whom the fount of all authority, including law, lay, had to respect both liberty and property of every citizen in the realm. This again was important. It went right down. And he was to do this by the law and by the judgment of the various peers. At that point of time, it was considered correct only if you are judged by your equals. So somebody should not be below or above you. This was the 39th article. The 40th article makes even more interesting reading because it says that we will not sell justice. Interesting at that point of time. Neither will we delay or deny justice. Now with this background, the three names I have chosen, fortunately Dushyant gave me the opportunity of choosing a topic of my choice, have to do with Magna Carta in the sense that each one of these three great Chief Justices, Lord Mansfield, and each of them, mind you, belonged to a separate century. Each was a colossus which bestrode a particular century. Lord Mansfield bestrode the 18th, Chief Justice Marshall of the United States Supreme Court, the 19th, and our great Chief Justice B.K. Mukherjee, the 20th. Each of them had liberty at his heart. And each of them were great exponents of the law as they saw it. Lord Mansfield of the law merchant, because at that point of time it was commerce which was predominant. Chief Justice Marshall of the Constitution, of the then new Constitution of the US, and Chief Justice Mukherjee of our new Constitution at the time, that he laid down his great decisions. Coming to Lord Mansfield's first, he was a remarkable man. He was a Scotsman, William Murray by birth. And he was a person who was Solicitor General and Attorney General. So he was a law officer for about 12 years, till 1756. At the time, it was important that the Attorney General be first asked to become Chief Justice of the King's Bench. And Lord Mansfield was so asked. He accepted. And he reigned over the King's Bench, actually reigned for 32 long years. He, in fact, built the commercial law on which all of us rely even today. What was important was, and it was called the law merchant at the time, that the law should follow the merchant and not the other way around. He had great practical wisdom, quite apart from his relying upon principle. He used to always ask for principle. Case law didn't matter to him. Now, the law followed the merchant in a very practical way. And the illustration I'll give you at the moment will show you how practical this great man was. There was a person who was to be governor sent to Jamaica. And as governor, he was to combine all the three so-called the separation of powers doctrine that we know today. He was to combine all three in them. And Lord Mansfield's advice was asked for so far as the judicial department was concerned. Lord Mansfield told him, do exactly as your heart and your head tell you. But be very careful. Don't give reasons. Because if you give reasons, you are bound to be wrong, but your conclusion is bound to be right. Now, it was this practical advice that he gave that this particular governor of Jamaica that actually constitutes the law merchant as we know it today. Why do I say this? First and foremost, he infused morality into the law. This is very important. In those days, you had to have present consideration for a contract. You couldn't have past consideration. Least of all, you couldn't have no consideration. Now, suppose somebody, when he was no longer a minor and became 18, gave a promise and said that I will actually honor a particular debt that was made during my minority. Lord Mansfield said, that is something which is in the nature of a promise. It may not be a contract yet, but it forms a kind of estoppel. And because it forms that kind of estoppel, I will honor it though it is not made with consideration. Now, things like this were very unusual in his time, which is why he was regarded like Lord Denning in our day as a very unusual judge. Another thing that we take for granted today is what Lord Wright said in the classic judgment of Hillis versus Arcos, which is reported in 1932, and which only stated something that Lord Mansfield said for the first time in the 1760s. And what he said was that businessmen often make agreements in extremely clumsy language. But that doesn't necessarily mean that there is no agreement, or that we should refuse to enforce an agreement if we find one because of lawyers' sophistry. Hence came the rule, and that's why I said the law was to follow the merchant. You are to divine what the merchant exactly did and then to work around it. So usage, custom became very, very important. And this is how the law merchant developed slowly, as I said, principle by principle and not case by case. Now, Lord Mansfield is known for a couple of very great things that he did during his tenure. One of them is the famous Somerset case. Now, we are talking of about 80 years before the great Dred Scott case in the United States, where Chief Justice Taney, in 1857, which is the year of our mutiny, actually laid down as a matter of law that a black is property, doesn't exist as a human being. 80 years previous, Somerset was the particular slave brought by a slave owner to England. And he wished to take the slave back as his slave. The slave petitioned the High Court, which was the King's Bench at the time. Lord Mansfield held in his favor, stating that slavery is an odious thing. That's the first important comment that he made. And being an odious thing, it needs to be grounded first in positive law. Therefore, unless I find positive law which endorses slavery, I refuse to endorse it. He found no such positive law. And then with the famous words with which he is accredited, he said, let the black crow go free. This happened in 1773. The other famous thing that happened in his time concerned a man called John Wilkes. Now, Wilkes was the editor of a rag called the North Briton, in which he wrote scurrilous articles about everybody, including King George III at that point of time. He so rubbed up the establishment that ultimately he was forced to flee, lived in Paris for 4 years, and then an externment order soon followed. He was stripped of being a member of parliament, but then came back after 4 years, stood for elections and got re-elected. He gave an undertaking to the King's Bench that he would honor that externment order if somebody wanted him out, and they wanted him out almost immediately. So he challenged it. When he challenged it, what was important was that Lord Mansfield ultimately went through the entire laws of the realm, the criminal law particularly, found no basis for the externment, even though it was fundamentally based on his writing something scurrilous against the king himself, and finally struck down that order. So he was also a man of great courage. One other very interesting thing happened in his time, which was known at that time as the Gordon riots. There was a man called George Gordon who railed against a certain Catholic emancipation bill. And he almost incited people to go and burn things, and people actually went and burned down many things, including Lord Mansfield's own house, which was burned down to a cinder. His library was completely finished. And finally, Gordon had to face trial for sedition and face trial before Lord Mansfield himself. And look at the man's greatness, that a man who had actually suffered as a result of Gordon's incitement finally said that on a preponderance of probability, there wasn't the necessary evidence, and let Gordon go. Now, all this is being said to you because this shows you that the man was a colossus. But even colossi like Homer nod sometimes. And this colossus, in his 32nd year, long after he was a spent force, still refused to demit the office of Chief Justice. Finally, when he had to, he did it with little grace. And for the 5 years that he continued to live, somebody or other would come to him and report the day's proceedings in the King's Bench, which he had never mentally left. This now brings me to the second great colossus. When we speak of Chief Justice Marshall, we are speaking of somebody who probably is the greatest judge, at least in constitutional law, in perhaps any jurisdiction anywhere in the world. That he became Chief Justice at all is a matter of chance. He happened to be Secretary of State, which is something like our Home Minister, in the second administration, President Adams's administration. And the time came to appoint a third or a fourth Chief Justice, depending on how you look at it. Because the second man, a man called Chief Justice Rutledge, actually served as Chief Justice for 2 months but was not confirmed by the Senate. Oliver Ellsworth, who was the third or the second, whichever way you look at it, suddenly demitted office owing to ill health in 1800. And it came upon to Adams as the second president in the last days of his presidency to appoint a Chief Justice. Couple of front runners were persons already on the court. One or two of them said no. And finally Adams, in exasperation, because he didn't want to let slip this opportunity to his arch rival Jefferson, with whom he didn't get on at the time, said, why don't you become Chief Justice? And it is in this kind of fashion that the greatest judge in any jurisdiction suddenly had the Chief Justiceship of the United States thrust upon him. And he suddenly accepted it. Now, at the time he accepted it, I must tell you that to become either Chief Justice of the United States or to become a judge of the United States was no big deal. In fact, the very first gentleman, John Jay, was a person who left the Chief Justice because there wasn't much work, there wasn't much power, there wasn't much substance. Those days, judges had to go riding on circuit duty, which was terrible because in winter, they had to go all over the northeast of America today and actually sit in different places. This stopped only sometime in the 1890s. So this was not a coveted job. John Jay stepped down, became ambassador to the United Kingdom, was asked a third time, refused to become. Rutledge, as I told you, went the way he went. Ellsworth just about sort of accepted. And when this was thrust upon John Marshall, this was perhaps the least coveted office in the United States. Now, one of the very first things that he did, because by then now a new administration had come, the Jefferson administration, and Jefferson's Secretary of State was James Madison, who succeeded him as president and became the third president of the United States. Now, Madison is called the father of the US Constitution. Why? Because not only did he actually father it in the sense of changing the original draft of Gouverneur Morris and making the Constitution look somewhat like we see it today, he also insisted that there be a Bill of Rights, which was then passed by way of amendment later, which was entirely his brainchild. So you had the father of the Constitution now as Secretary of State and the father of constitutional law, the cousin of Jefferson, Chief Justice Marshall, sitting as Chief Justice of the United States. And one of the first matters that came before the great judge was the celebrated case of William Marbury versus James Madison, who was then Secretary of State. Now, Marshall perhaps should not have sat at all, because it was as Secretary of State that he signed the commission given to William Marbury. Everything was done. Only thing was that the commission had ultimately to be delivered. And because these were midnight orders, somehow or the other, a few of these persons, commissions were not delivered. And therefore, Marbury collectively petitioned the US Supreme Court and said, everything is done in my favor, including your signature, Mr. Chief Justice, as Secretary of State. Why should you not then give me my Justice of the Peace? Issue a writ of mandamus against the government. Marshall not only hears the case, but in a judgment which is one of the most brilliant judgments logically, because he started, as I told you, on a tabula rasa. He had to look at the Constitution as it was. First reasoned as to how, of course, Marbury must be given a writ of mandamus. What else is a writ of mandamus for? But then he found that the Judiciary Act, which had been passed by Parliament in 1789, and which also gave him the power to issue writs of mandamus, the US Supreme Court, would conflict with Article 3 of the US Constitution. Now, I must tell you, the US Constitution is a remarkably small and concise document. Article 1 deals with the legislature, 2 with the executive, 3 with the judicial power. And Article 3, Section 2, Subsection 2, or Sub-Article 2, specifically said that only if a state happens to be a party against somebody in the US Supreme Court and ambassadors and the like, did the Supreme Court have original jurisdiction. Otherwise, the Supreme Court could only have an appellate jurisdiction given to it by Congress, which is the legislature there. So he said, reading Article 3, that the original jurisdiction is an extremely limited one. Congress cannot now, by this Judiciary Act, expand it, and therefore laid down what we take for granted and which is part of our Constitution, our Article 13, namely the doctrine of judicial review. And he did this with a masterly process of reasoning. The reasoning is something that I commend to you. I don't have enough time, otherwise I have gone into it in great depth. And ultimately found that the very document that he had signed as Secretary of State would be of no avail, because unfortunately he did not have the jurisdiction to issue the writ of mandamus that was sought by William Marbury. Now, apart from this great judgment for which he is known worldwide, Fletcher versus Peck in 1810 is another very great judgment, where for the first time he had to lay down what was meant by the fact that Congress shall not, neither will the states, impair the obligation of contracts. Now, we don't have any such thing in our Constitution. They had it from the start. And the facts of this case will tell you to what lengths Marshall went to uphold principle. The facts were that the legislature of Georgia had in fact given vast lands at throwaway prices to a couple of scoundrels. And when the legislature was re-voted in, another group came in. The first thing that they wanted to do, and that they actually did, was to repeal the law giving these lands. Marshall was faced with the obligation of contract clause. And looking at that obligation of contract clause, he held whatever the facts, ultimately both the Congress and the Georgia legislature are bound by a superior law. You have in fact entered into a particular contract, howsoever imprudent it be. You are bound by that contract. And therefore, in 1810, struck down another piece of legislation, this time by the legislature of Georgia. A third judgment in chronological order is the celebrated case of McCulloch and Maryland. It is celebrated for so many reasons. We know it as the judgment in which he lays down the famous, the most famous perhaps phrase or aphorism in constitutional law. It is a constitution we are expounding. And he said this because what he was faced with in McCulloch was to look for corners and recesses of the Constitution to finally come out with the judgment that he came out with. In that case, the state of Maryland purported to tax a bank that had been set up by Congress. Now, the first question that faced him was, could Congress at all set up the bank? Because unlike our Constitution, where the residuary power lies with Parliament, there the residuary power lies with the states and then the people. And Congress only has enumerated powers in Article 1, Clause 8 of their Constitution. So either it fits those powers or it doesn't fit those powers. He readily admitted that the setting up of a bank by the legislature was not actually within any one of those enumerated powers. But he found that Congress had to regulate interstate commerce. Congress generally had to see that the nation's finances were in good health, etc., etc. And then said that the last clause at the end of the entire enumeration, which says that Congress may do anything that is necessary and proper to execute what has come earlier, can be utilized in this case. Because for all these purposes, unless you have a bank, it is not possible. It is necessary and proper for the United States to have a bank, therefore, to see that the nation's finances are in good order, to see that interstate commerce, etc., is looked after by Congress. So that was hurdle one that was got over by the necessary and proper clause, which was the last clause in the enumeration. The other, even more major hurdle was that there was absolutely nothing in the US Constitution which said that a state cannot tax an instrumentality of the center. So we will assume that the central bank now is an instrumentality of Congress, the center. Here again, he had to undergo some very deft reasoning. And his reasoning was as follows. What he said was that basically, if the center were in fact to act under the Constitution, it must be free to act in all ways. There can be no clogs, burdens put on the way. Taxation is one such burden. So as a matter of inference, the very fact that the center is to act whenever there is a national disaster, whenever in national interest basically, the fact that a state may tax the center would lead to a burden. And this is where he used this great expression, it is the Constitution that we are expounding. Because never forget, we are not looking at a statute where we have to find something in the statute, go by the literal rule, go by Hayden's case, etc., etc. We have to find from the words used some principle, what he called the spirit, which must emerge from these words. And when finally we find that principle, we have to apply it in constitutional law. And applying this principle which he found from reading the Constitution as a whole, he struck down that tax. We have no such difficulty because we have Article 285 as a result of this experience. So this is case 3. Case 4 again is a very important case, Gibbons versus Ogden. I am going in chronological order. This is a judgment he laid down in 1824. And here what had happened was that the New York legislature had created a monopoly over the Hudson River and said that this is intrastate. Since it is purely intrastate, I can do what I like. It doesn't affect the Commerce Clause, which said that Congress, that is the central legislature, may regulate commerce among the various states. Marshall said this kind of reading of the Commerce Clause will finish the nation. Anything that is of significance, whether intra or inter, and significance to the nation is something that is basic to the Commerce Clause. So therefore again, you will find that in this case, Gibbons versus Ogden, he struck down the New York monopoly and said that the Federal Licensing Act went even to intrastate rivers, purely intrastate, if they happen to be of significance in national commerce. There isn't much time to tell you much else about this great man, except that, and like Lord Mansfield, he reigned for 34 years. Lord Mansfield, if you remember, was 32. This man reigned for 34. And he in fact died in earnest. One of the last things, unfortunately for him, was a decision which he gave in favor of the Cherokee Indians. This again concerned the state of Georgia. Because Georgia, by legislation, tried to take away the rights of these Indians. And he struck down that Georgia legislation and said, no, you must give these property rights to these people. Andrew Jackson, who was by then president, is reported famously to have said, Marshall has decided something, let him enforce it. And it was left at that. 150 years later, in Cooper versus Aaron, this is now in 1958. So we are moving from 1834 to 1958. When desegregation was ordered by the US Supreme Court, and when the governor of Arkansas did exactly the same thing that President Jackson did 125 years before, this time the court, our bank, called upon the Federal Reserve and said, compel him. Now here again we have no difficulty seeing this experience because our founding fathers gave us Article 144. Because under our 144, everybody has to act in aid of what the court says. This now brings us to our great son and our great lion, Bijan Kumar Mukherjee. I first got to know about this man's greatness only because Justice William O. Douglas of the US Supreme Court delivered a Tagore law lecture here in 1956 entitled From Marshall to Mukherjee. Now, the first two persons I spoke about, if you will remember, are persons who had very long spans, one 32 years, one 34 years. B.K. Mukherjee had about 5.5. When you compare 5.5 with 32 and 34, what could this man have done? Yet he did almost everything. Like Napoleon, he was born on 15th August. And 15th August is a day on which, as you know, our nation is born as well. Napoleon, apart from having been a great general, is considered a very great lawgiver. Now, why was he a great lawgiver? Because he personally oversaw what is called the Code Napoleon, which is a code of civil and criminal law. When he was first consul, before he declared himself emperor, he had two other consuls with him, one of whom was a man called Cambaceres, who was a lawyer. So he asked Cambaceres, go and collect the law as we have it today and give me article by article what a strict constructionist says against what a liberal constructionist says. So that when ultimately article by article the Code Napoleon was actually debated in the assembly, you had two rival views. And what is interesting is that this man was not a lawyer at all. He was a genius. On his way to Egypt, he picked up the Quran and said, I could pray like the Mohammedans in any mosque, no difficulty. This great man actually deliberated over most of the sessions in that assembly and sometimes dictated articles himself, which is why not only was it under his aegis, it was also Napoleon's handiwork, his own handiwork. And like other great lawgivers, Justinian, Muhammad, etc., he also happens to have or find a place on the frieze on the ceiling in the US Supreme Court. Now, our great son, B.K. Mukherjee, started reasonably tentatively here. One of the first great judgments that he delivered was a dissent in Dr. N.B. Khare's case, reported in 1950. Dr. N.B. Khare was a Hindu Mahasabha leader. And there was an externment order that was passed against him under the East Punjab Safety Act. He challenged the constitutional validity of the act on the newly enacted Articles 19(1)D and E, which allowed you free movement throughout the territory of India. Chief Justice Kanya, speaking for the majority, upheld the sections as well as the externment order. First and foremost, he said that the act itself is a temporary one. It will expire in any case in August 51. So it doesn't matter that the section under which this man is actually arraigned did not provide for a time period for which he should be externed. Secondly, another section which said that you may give the person, may communicate the reasons for his externment, he read as shall. Justice Mukherjee refused to do either. Justice Mukherjee said this is a direct infraction of every citizen's right to move freely throughout the territory of India. The fact that the act is a temporary act is neither here nor there, it may be extended. And the fact, therefore, that you may be externed without any outer period is itself a grave infraction of that right. Struck down the act as well as the order. He also refused to read the word shall in the place of the word may, saying, I will do violence to the language. The legislature intended that it should discriminate in cases like this and give reasons to some and not give reasons to others. So he began with a great dissent in which he was joined by another very great judge, our Chief Justice Mahajan. Another early judgment in Bharat Bank was also a case in which the great Chief Justice dissented. He said an industrial tribunal cannot possibly be the kind of tribunal that is referred to in our Article 136. And said that, look, basically its hearing procedure is not like you'd hear something in a court. The award that it pronounces doesn't have any effect until the government of the day publishes it. And thirdly, even if it publishes it, the legislature may sit on it and annul it, or defer it, or do whatever. So strictly speaking, again he was right, but he was in the minority. And he said, the tribunal spoken of under 136 is something that is akin to a court. It cannot be a body like this, which doesn't have to follow a law, short of industrial law, which believes in conciliation, and ultimately may give an award which may never be enforced by the executive. After this, a number of great judgments come one after the other. Amirun-Nisa Begum is one such. Now in 1953, the Walidullah succession case came before the court. Walidullah was some nobleman in the Nizam's dominions. He had married several women, and two of these women claimed to be his wives. A British agent there was asked to look into all this by the Nizam, who had then become a Raj Pramukh under our constitution and therefore couldn't issue a farman. And Sir George Spence, the Englishman, came out with a report. And in his report, without hearing the ladies, without more, he said, no, they were not wives, therefore not entitled to succession. That report became the basis for the Hyderabad Legislative Assembly passing a law. And the law was remarkable. The law basically said, we are deciding a case. Said, it is decided that these two ladies are out of succession since they were not wives. And section 4 of that law then said, the High Court will execute this order passed by us, the legislature. Strangely enough, nobody argued before him that this would be a direct infraction into the separation of powers doctrine. What was argued on the other hand was Article 14. And what succeeded before him was also something fantastic. He laid down long before Justice Bhagwati in Royappa that an arbitrary act, be it of the legislature, and this is where it's important because there is some conundrum about whether the legislature can be arbitrary under 14. Be it the legislature, be it the executive, an arbitrary act followed by something so unreasonable that you could call it discriminatory will violate Article 14. Each one of the three principles you will find in that very, very forward-looking judgment. And ultimately agreed with the Hyderabad High Court and struck down this particular act on the ground that it violates our equality clause. Another great judgment which came from his pen is the great judgment of the doctrine of colorable legislation, Gajapati Narayan Deo, where it was argued based on a number of Canadian judgments which had gone to the Privy Council, including Union Colliery Company versus Bryden, where an argument succeeded saying that even though your law on the face of it happens to deal with coal mines, actually it is to exclude blacks from coal mines. And that being the case, like the Chinese laundryman's case, Yi Kuo in the US, we will say that it is outside your ken and you, the provincial legislature, cannot pass such law. He went into all this in great detail and ultimately laid down for us that there is nothing like mala fides to be attributed to legislation. Either it is within the legislative power or it is not. And therefore he picked up the great doctrine of pith and substance with all its sub-doctrines and said either we find that in substance it is here or it is here. And also laid down that this alone is what is colorable legislation, nothing more, nothing less. Another great judgment in 1954 would be the great Shirur Mutt case. Now this case again spanned so many articles, gave us the basic distinction between tax and fee, that a fee basically is something paid for a special service rendered, and ultimately went through various sections of a particular Hindu Endowment Act and struck down most of them, both on grounds of tax and fee and on grounds that they violated property rights, including religious rights. And one very lovely passage in the judgment speaks of what is meant by religion in Articles 25 and 26. He said, here we cannot borrow from anywhere outside, because we have religions within our midst, like Jainism and Buddhism, which do not believe in and do not speak of God. So there is no necessity for a deity in any religion. It is enough that there is some body of followers which profess a certain belief which has to do with the hereafter. In fact, even if it doesn't have to do with the hereafter, like the Charvak school, for example, it would be protected as a denomination, if not as a religion. One could go on and on. Perhaps the last judgment I'll advert to is the great Ram Javaya Kapoor, where he expounded on our form of government in the most brilliant fashion possible, quoted Walter Bajaho in telling us as to how the cabinet is like a hyphen or a buckle that joins the legislature and the executive, and ultimately said in that famous statement that what is the executive power if not the residue after one has dealt with the legislative and the judicial. I think with this, I have, overstepped my time limit. I can only end with Shakespeare's great words. Here went a Caesar, when comes such another? Thank you very much.
Thank you, Justice Nariman. That was truly brilliant. It was very instructive, educative, and enlightening. Thank you very, very much for coming and joining us. You can see the enthusiasm and the kind of, fervor that has been created because of this. And this is our first experiment at this. And I have no doubt that we will be doing it in future, and looking forward to you for support. And I must also thank each one of you, especially my distinguished seniors, every one of you. It's been a privilege for us, all the young friends who are here. It's been a pleasure to have you all with us, and thank you very, very much for supporting us in this move. We want to have this lecture series in a regular way. In fact, we are discussing just now with Professor Madhav Menon to start an continuing education program for lawyers. And post-July, we intend to start on a every Friday basis such a program where we'll be banking on the help from some of the most distinguished seniors who are sitting in front of me, many of the judges hopefully, and other jurists whom Professor Madhav Menon would recommend. So I think all of you continue to support us. Thank you very, very much. Have a lovely evening.